Yes, Mr. Sully.
My lords, when we broke, I was making submissions about Putnam. Just one thing, I need to move on, but one thing that I would just emphasise about Putnam is the language that Lord Justice Bingham, as he then was, used towards the end of page 759 in that passage where he talks about collective integrity. And he talks about the high regard in which juries are held depending on their collective integrity and their individual integrity. And that's important in one sense because it demonstrates how, in our submission, judges actually, although obviously judges need to avoid discharging unnecessarily because it's a waste of resources, etc. At the same time, judges should not be reluctant if the circumstances arise to discharge the jury, because it's by doing that that the regard of the jury is, in one sense, preserved. It has one other factor, that it has one other result, which in our submission is demonstrated by the facts of this case, and explains why discharging the jury is not that uncommon, we would submit, and that's that discharging the jury in the right circumstances prevents people having to then exercise appeal rights, essentially potentially being held on appeal, in custody rather, until the appeal is heard. It ensures effectively that someone's fair trial rights are vindicated as soon as possible. I'm going to move on fairly quickly because of time, but there are a couple of things I just want to make, a couple of points I want to make about the suggestion, which seems to be at the heart of the prosecution case, essentially, which is that all of this could be dealt with by jury directions. And the first point I want to make is it links back to the question, or the point I think my Lord Reid put to me just before lunch. Jury directions obviously can be, I was about to say but I don't think it won't always be the case, and that's why I changed my language. Jury directions can be important ways of keeping a trial on track. The fundamental problem, though, in this case, there are two fundamental problems that explain why jury directions, even if they had been in stronger terms than the ones in this case, would not have been enough. And the two fundamental problems are this. Firstly, it goes back to a point I made this morning. One of the jurors had already been willing to offer bribes. He was willing to break the law. Directions assume that the juror will comply with what they're being told. But if a juror is willing to demonstrate that they are willing to break their oath, willing to act unlawfully, directions cannot solve that in our submission. The second problem with a direction is that implicit in Putnam, and what is said in Putnam about the potential for late reporting, for example, demonstrating that a juror had failed to comply with their oath and was going to be unable to avoid being biased. Implicit in Putnam is the need to know how far the poison has spread, to use the language of Putnam, before giving a direction, because directions will only work if the poison hasn't spread too far or hasn't become too deeply embedded in individuals' thought-making process. Here, because of the limited information about what had actually occurred, in our submission, there was no way of knowing whether the directions were sufficient. And that's one of the reasons why questioning the jury can be important. We would say, and I'll come back to this in reply if necessary, but it's probably clear from our case. In any event, all that was said in this case, of course, was that the jury were reminded of their oath. Smith, I won't take you to it, but it's 7671, House of Lords at para 24, makes it clear that directions need to be apposite, clear, and emphatic. They were not in this case. And there's no reason why the jury couldn't have been expressly addressed effectively about bribes and how they should ignore the bribery attempt. Because, of course, on the evidence given, or the account given by the forewoman, not technically evidence, but on the account given by the forewoman, everyone was aware that there'd been this approach. Everyone was aware that one of their number had been placing a bribe. But as I say, fundamentally in our submission, this was a case, and there have to be those cases where it's just gone too far. The Crown has raised the issue of the proviso. In our submission, the proviso is inappropriate in this context, and we've certainly, neither side has been able to identify, as far as I'm aware, any case where the proviso has been applied in circumstances where an appellate court has reached the conclusion that bribery or similar problems have occurred. The reason for that in our submission is this. Under the Charter, as you've seen, there is a constitutional right to be tried by an independent tribunal. The Jury Act, unsurprisingly, given what is common practice in many countries around the world, provides that that trial must be by a jury. No one has, in this case, none of the defendants in this case, have waived their right to trial by jury. Waiver, we make reference to it. Again, I won't take you to it because it's probably trite. Miller and Dixon, Lord Bingham, waiver has to be voluntary, informed and unequivocal. The reference to that, if you want it, is page 7008, paragraph 31. So no one has waived their rights. If the proviso were to be applied by this court in relation to the jury issues, it would be this court then effectively deciding on guilt, having not heard any evidence, having not been able to assess the witnesses, having inevitably, and this is no criticism of any party, having inevitably limited information. And that's, as I say, not consistent with the rights that I've just described, the clear rights as a matter of Jamaican law to trial by an independent jury. That's why in our submission, the Court of Appeal was right in Brown to say it doesn't matter what, effectively paraphrasing, what the strength of the evidence was, because ultimately there was a right to trial by an impartial tribunal. We submitted yesterday a judgment in the Supplementary Authorities bundle by Chandon, which is a judgment of the Court of Appeal of Guyana, page 16 and 17 of that supplementary bundle, which is page 226 and 227 of the report, which is last two lines of page 16 and the first 5 of the next page, adopts the approach I've just described, which is saying you can't apply the proviso because there was a constitutional right to trial by 11 jurors. Actually, not a constitutional right, but a right as a matter of law to trial by 11 jurors. One of the reasons for that, I've given a number of sort of fairly fundamental reasons. That's obviously also consistent with the approach in Putnam, as I took you to. One specific reason for that is that, as this court will be aware, and as is clear, for example, in the judgment in Bonnet-Taylor, which is in the authorities at 6289, paragraph 20, the normal approach that is often adopted in things like fresh evidence cases is to consider the impact, essentially, of whatever occurred or didn't occur on the juries, on the jury. Well, in a fresh evidence case, one can do it. And what that does is respect the role the jury plays. It looks at what the jury must have concluded, which is that the individual who's appealing was guilty, and then considers what impact fresh material might have. Here, one doesn't have that starting block, and that's why applying the proviso essentially would be this court determining for itself guilt, because it doesn't have a reliable starting point. So in my submission, it's not surprising simply that there doesn't appear to be any case where the proviso has been applied in a case where there's a problem with a jury. Well, a problem in the sense of certainly a lack of independence. I mean, there may be other problems, but. My Lord,
I'm sorry. I'm not meaning to look pained.
Yes.
I'm trying to remember an authority. We had a case in this court. We had a case in the Supreme Court a few years ago where the judgment was given by Lord Wilson to do with unfairness by a trial judge.
Yes.
And the court, in the judgment, Lord Wilson said words to the effect that a judgment which is the result of an unfair procedure is a thing writ in water from which nothing can follow. And you might rely on that idea in relation to a verdict by a jury which one could not be confident was an unprejudiced jury.
Well, my Lord, yes, but in one sense I would put it even higher because of the role the jury plays in our system, because of the importance of the integrity of the jury being preserved, and because there is, in particular, a constitutional right to an impartial and independent tribunal. I mean, they are really important rights within the system of criminal justice. To state the obvious, to state and you are potentially denying that. I'm helpfully. It's extraordinary how quick juniors are these days. Seraphine, I'm told, is the judgment.
Right.
Para 49.
Yes.
Turning then to the issue of time of jury, I'm not going to spend very much time on it, partly because obviously in one sense, the jury shouldn't have been retiring at all on our case. But it does in one sense add to the overall concerns about this case, because it's quite clear, and the Court of Appeal recognised this essentially, that one of the reasons why the judge was keen to get the jury out, so as to speak, is because the trial couldn't continue without that juror. And so you had this situation where there was a potential need to take action against a juror who, and so a quick verdict was being sought. Now, the Jamaican bench book clearly recognises the potential pressures that can be put on a jury, and we would submit that one of the problems, if you have a jury that already has poison within it, to use that language again, one of the problems with pressure, the problems of pressurizing the jury become even more intense. And the reason for that simply is that if a jury is going to be potentially is going to potentially be influenced by unconscious bias, that risk increases if people are effectively pressurized to take a quick decision, not think through the evidence. You go to your prejudices, unfortunately. If you some people tend to go to their prejudices if they're under pressure. That's the simple point I'm making. And that there is clearly a recognition now that sending a jury out late puts pressure on them, and it particularly puts pressure on them in a situation such as Jamaica, where there is no opportunity essentially for the jury to be discharged. They know they're going to be kept together. They're not going to be able to go home until they reach a verdict. That's recognised. The passage I've been referring to in the bench book is at page 6801, paragraph 5 of the bench book. which recognises what it describes as a 3 p.m. benchmark, but recognises flexibility both ways. And so in complex cases, remember this is apparently one of the longest criminal trials in Jamaican history. In complex cases, it may be necessary to complete the summation earlier than 3 p.m. to avoid pressure.
I'm sorry, could you give me that page number?
Sorry, 6801, and it's paragraph 5.
8601.
No, 6801.
Oh, I beg your
Sorry,
pardon.
no, that was probably me.
No, it's a better one.
And of course, in this case, you had the added complication that when the jury was sent out, they came back essentially at 5:35, were asked if they'd reached a unanimous verdict and said they hadn't. The reference to this is 5176. The prosecutor then pointed out that they'd not been out for 2 hours, which is the point at which a majority verdict would be reached. There's no direction essentially saying you may want to, you need to try and reach a unanimous verdict. That's inconsistent with another passage of the bench book that is at 8362.
And can I ask, in Jamaica, if they go out and they haven't returned a verdict by a reasonable time in the evening, is the practice to send the jurors home, or are they sequestered in a hotel?
They cannot be sent home, so they have to be sequestered, basically.
Yeah. Yes, and so are they kept in a hotel under court supervision?
That would be my understanding what we like, but obviously the bench book is premised on the idea that it's ideal that doesn't happen, really.
Yeah, but even sending, I mean, I know from my own experience, even sending out the jury earlier in the day, that you can still have them out overnight.
Yes, absolutely, obviously, and that's not uncommon. In
fact, sometimes it takes a number of days before they return a verdict.
But does sequestering happen in Jamaica? Because I noticed there was another case where the hearing went on till 1:30 in the morning, where you would have thought they'd all be in a hotel by then.
No, in practice, sorry, I should have been clear. In practice, it doesn't, because there's just no real provision for it. So the jury just stay late.
But there is a rule that they can't be separated once.
The Jury Act is clear on that. Yeah. They can't be separated.
So deliberations can go on for days and they'll just be kept without being sequestered in a hotel?
In principle, I suspect in reality that doesn't happen because of the natural I mean, we haven't put this in because it didn't seem relevant, but there is old English case law about juries being just reaching verdicts at 3 a.m.
Yeah. Yes, well, the leading case on coercion of a jury is one where the judge refused to let them have anything to eat or drink until they returned a verdict.
Have you got the reference to the Jury Act indicating that the jury cannot be?
Yes.
Once they've started deliberation, can't be.
Yes, I'll get
sent home.
I have got that in my notes. Sorry.
Well, don't bother now. But if it's not immediately, if somebody could just.
Yeah. No. Sorry. I just. It's section 47 of the Jury Act, which is electronic bundle 6805.
Thank you.
I think actually, just sort of as an aside, it was George Davis. If you remember, the George Davis is innocent. He was an early hours of the morning verdict. If that's a sort of historic.
That's not that long ago.
Yeah.
But they can be sent home, as I understand it, before they start to deliberate.
Yes.
So the judge who finishes summing up, say at tea time, could just say to the jury,
"Yeah,
well, that's why
come back tomorrow and you'll deliberate."
Well, that's why the bench book makes express reference to when you finish your summation, because that's really what determines it. So what I suspect happens, my experience of English courts,
save the last direction about unanimity and electing a foreman until first thing the next morning.
Exactly, and that's not uncommon even in England, where
Yes,
you're getting late.
regular.
You have 2 minutes worth of summing up.
Yeah.
But paragraph 5 in the bench book rather suggests that the solution is not, if you finish your summing up late, to send them home, but not to finish your summing up late.
Well, I think that it's because of the technical issue of when does their deliberation start. But all you need to do is have like one line of your summing up, and that
Just save the last sentence of your summing up.
Yeah.
Okay.
47.3 at page 6805 does imply, well, it does say that the judge can give directions as regards accommodation.
Yes, but
Regards accommodation.
Yes, but I understand in practice, and obviously I don't have direct experience, but those who do tell me this, that in practice that's not applied.
Thank you.
Final issue, and I so there are obvious issues in relation to the time in this case, particularly given the complexity of the case. In terms of what you should do if you're with me, and have concluded that the conviction should be quashed and the proviso shouldn't be applied, we would invite the court not to remit. This has obviously been outstanding. The appellants have all been in custody since the 30th of September 2011. That delay is likely to have had an impact on evidence. There are, as the court will be aware, because of the application for expedition, there are issues with the health of one of the appellants. There are also obviously constitutional issues, but they've been denied. We would submit constitutional issues, even if it's the jury point. They had a constitutional right to a fair trial. If we're wrong about that, though, we would invite you to consider remitting to the Court of Appeal so that the Court of Appeal can consider the issue of retrial. That, I think, concludes all I have to say. I think Mr. Buchanan has some additional submissions.
Yes.
Yes, Mr. Buchanan.
To be pleased with the court. Lord, please. Lord and ladies, I just wish to make a point. couple points, but to start with questions, the clarifications to questions. The first one being raised by Lord Lloyd Jones. And this would have been in relation to in relation to the chamber hearing. Now, in the Jamaican, context, the right of the accused to be present at all stages of the proceedings. The concept of the chamber hearing respectfully